Further hearing the appeal of the Law Debenture Trust Corporation PLC against Ukraine.
Mr. Howard, I should explain before you begin that we'll be observing the 2-minute silence at 11 o'clock.
Yes, of course, my lord. My lords, I'm sure we are all filled with a sense of déjà vu as we return in front of your lordships almost 2 years after concluding the argument in this appeal. However, this is not Groundhog Day, or at least we'll endeavour to make sure it is not Groundhog Day, as there has been a significant development in the law of duress since we last appeared before you, and that, of course, is this court's recent decision in the Times Travel case, or more fully, Pakistan International Airline Corporation and Times Travel. Now, the court may or will recall that this appeal, or this aspect, concerns the validity of Eurobonds issued by Ukraine under a trust deed entered into with the appellant Law Debenture. The bonds were tradable, listed on the Irish Stock Exchange, and all of the agreements were expressly governed by English law. Ukraine seeks to set aside the contract on the grounds of duress. It's common ground, as we understand it, that because the contracts are expressly governed by English law, whether or not there is duress is also governed by English law. Now, the duress alleged consisted of unlawful threats made by the Russian Federation against Ukraine, including as to its territorial integrity and the application of unlawful trade measures and economic pressure. The alleged unlawfulness arose as a matter of international law, which the trustee alleges did not form part of English law and was not justiciable by the English court, and so could not give rise to a defence of duress as a matter of English law. Essentially, at first instance, Mr. Justice Blair upheld the trustee's contentions. The Court of Appeal, for its part, did not disagree that the alleged threats were not unlawful as a matter of English law, but said, and this is the important point for present purposes, that the English law of duress did not turn on breach of domestic law, but on the criterion of illegitimate pressure, which could be determined by whether the pressure, albeit not unlawful, was of a type that was, quotes, morally or socially unacceptable. Accordingly, the Court of Appeal proceeded on the basis that lawful act duress existed as a matter of English law, that lawful act duress could be made out if the conduct constituting the alleged duress was morally or socially unacceptable, and that international law set out the standard as what could be considered, in the case of states, morally or socially unacceptable pressure. Now, leaving aside the trustee's arguments before your lordships that it is impermissible to use international law in this way, that it effectively, via the back door, does what could not be done by the front door, the question arises as to whether the Court of Appeal's approach withstands scrutiny in the light of Times Travel. Our submission is that the position is straightforward and that it does not. In addition to the problems with the Court of Appeal's judgment previously considered, Times Travel now removes the very foundation for the Court of Appeal's approach, and indeed reinforces the points that we've previously made, that Ukraine does not have an arguable case to set aside the notes on the grounds of duress. So, my lord, I propose to cover the following 4 topics this morning. First, I want to identify what this court said in Times Travel about the circumstances in which lawful but illegitimate threats can constitute duress. Secondly, I want to demonstrate how Times Travel is relevant to the present case by looking first at Ukraine's case on the alleged illegitimacy of Russia's conduct and how the Court of Appeal dealt with that. Thirdly, I will identify what we submit is the fatal effect of Times Travel on the Court of Appeal's approach in this case and on any remaining contention by Ukraine that Russia's conduct constituted lawful act duress as a matter of English law. And then finally, I will turn to demonstrate the obvious flaws in Ukraine's latest rearguard action, that in fact it doesn't need to identify any unlawfulness or illegitimacy at all, because it says the threats in this case were duress to person or duress to goods or somehow contrary to public policy. So, my lord,
before you
yes, Mark.
On that, it's very helpful to have that introduction, if I may say so. And One of the aspects of the structure of the whole argument that's taken place in the case is that it seems to be based on an assumption that duress requires either unlawfulness under English law or what was referred to, I think, following Lord Justice Steyn, as illegitimate pressure.
Yes.
And the latter has been the subject of, obviously, discussion in Times Travel. I'm just wondering whether that binary structure is necessary. I mean, nobody has actually looked, well, we certainly haven't looked in the hearing, and I'm not suggesting we do so now, but we haven't looked at the basics of the law of duress and whether, in fact, unlawfulness under specifically English law is, whether the field is occupied by, on the one hand, unlawfulness under English law, and on the other hand, illegitimate pressure.
Yes, well, my lord, that is part of the debate we're now having, and our submission is that the English law of duress does require unlawfulness or illegitimate pressure in the sense that Times Travel has spoken about it. Yeah. And certainly in the sphere of contract, we say that is the case.
And the unlawfulness has to be unlawfulness under English law?
Yes.
And how do you deal with the situation, for example, of the, I don't know, one Frenchman forces another Frenchman in France to enter into a contract by holding a revolver to his head?
Yeah. My lord, that's a very simple point, and that's actually dealt with in the Dimscore case, if you remember. That there, the pressure that was being applied was in Sweden.
Yep.
Remember, where it was legitimate to apply to black ships.
Yeah.
But as a matter of English law, it wasn't. So you applied English law to that.
Yes.
You didn't say, well, no, that's not illegitimate pressure because Sweden allows it. Now, equally, if you had something done in France, well, it's exactly the same situation.
So it's enough that it would have been unlawful if the act had been carried out. It would have been unlawful under English law if it had been carried out in England. Yeah.
Yes, exactly.
And is there any authority at all dealing with, I mean, I suppose there can't be, or we'd have seen it, but I take it there's no authority dealing with unlawfulness under international law other than this case?
As far as we are aware, and obviously there's been a lot of research on both sides, there isn't. But that takes you back to the principle. I mean, your Lordship will recall my submission from, or you may not, but from two years ago. We say, if you take the example your Lordship gave me, say there is pressure, there's a threat in France, which French law says is improper, illegal. But as a matter of English law, we say there's absolutely nothing wrong with it, say applying the Times Travel point. Then because if it's an English law contract, then you apply the English law approach and you say that doesn't matter. In other words, the French law is irrelevant to an English law contract. Now, we say the same principle applies where the threat is being made on the international plane. It's got to be something which constitutes unlawfulness as a matter of English law. Now, and that takes us back to the points that we were making previously about the nature of matters on the international plane. And for instance, you'll all be familiar, and we went through it last time with Belhage and the paradigm case of, for instance, acts of war are not an area that the English court goes into. So we say a threat between states is not something that the English court could categorize for English law purposes as unlawful, because it's something that's happening on the international plane, not on the domestic plane.
Belhage were a specific person.
Well, the distinction is if you move off the international plane and effectively onto the domestic plane. then I mean, that can then be an exception, or there are other exceptions. But if all you're talking about is one state, we'll have to look at what Ukraine says the threats were here. But if you have something which is actually, and one needs to remember this, of course, that we may have a particular view politically about Russia and Ukraine, but there are, as it were, hurly-burly between states happening. One only has to open the papers day in, day out with what one sees in the Middle East, for instance, recently, the disputes between the different Sunni and Shia states, and blockade. Now, in our submission, that is the classic area where the English court cannot assess and say that is wrongful. And that's why, I mean, for instance, in the law of tort, you wouldn't do that. And we say it's very odd in a situation where you're saying there's duress that one is going to then assess it. Now, the Court of Appeal got round this, and it's very important. That's why we have to look at times travel carefully. Court of Appeal, as they got round it, this is an unfair way of putting it. The law then was morally or socially unacceptable conduct was sufficient between, as it were, domestic parties. And so the Court of Appeal said, oh, well, we can assess conduct between states. We can consider what's morally or socially unacceptable by reference to international law. Now, that's what I say they're really just doing by the back door, what you can't do by the front door. But my Lord, I'm going to go now to the Times Travel case. Of course, now, 4 of your Lordships, of course, were in the case, and it was argued recently, so I will try and do it quickly. But it is, in our submission, it is, I mean, it's obviously, that's why we're here for Times Travel, but it's an important decision, not only for this case, but also for the implications of this case more generally, in that this court has taken a deliberately narrow approach to the law of duress, and recognised that in our history, in our jurisprudence, that duress has been recognised in a very limited sphere when you're talking about lawful act duress. And one needs to, our submission overall is that the effect of what Ukraine is saying here would in fact totally undermine what this court has said in Times Travel. Now, my Lord, the judgment is in the 2021 authorities at EF 154, which is tab 236. And of course, the leading judgment was given by my Lord Hodge, and my Lords Lord Reid, Lord Lloyd-Jones and Lord Kitchen agreed. Now, although Lord Burrows dissented in part, there was, of course, much where your Lordships were in agreement with him, and at paragraph 1 of the judgment, Lord Hodge cross-refers to the paragraphs that with which there was agreement. Now, and so I'd like to first pick up some points from Lord Burrows. So if we could just, I'm going to give you references, obviously I'm not going to read out chunks of the judgment, because I'm sure everyone's familiar with it, but at EF page 182... Can you,
sorry, I just need to catch up with this.
I'm sorry, my Lord.
Is there an MS number, or...?
For this one, it's EF number. So
EF,
yeah,
yes.
I don't quite...
Sorry, I mean, I had this at home, but I've come in here and I'm trying to deal with a different
of course.
system.
So I don't know what EF means, but it's EF page 1.
There isn't a hard copy version of this?
Yeah, there is. It's in 2021 authorities, and it's at tab...
No, I don't know if I don't think we have that.
No.
We don't
Is there anyone among this big team who could lend me one?
Does somebody have a...
Sorry, it's just catching up from...
Does somebody have a clean copy?
I mean, I had it at home on my other laptop, but I haven't got a hard copy of it.
Yeah.
Thanks so much. Sorry. Right, thank you.
So, my Lord, it's at tab 236 in that hard copy bundle.
Thank you.
And so if we could go to paragraph 78 in Lord Burroughs, page 182, EF 182. And if I can remind you that what at 78 Lord Burroughs does is he identifies actually what is the principle of English law relating to duress. So you see in the first sentence, he says, where it's alleged that one contracting party has induced the other to enter into the contract between them by duress. The case law has laid down that there are two essential elements. The first is a threat that is illegitimate. The second is that the illegitimate threat or pressure caused the claimant to enter into the contract. Now, in our submission, what Lord Burroughs is identifying there is actually the elements of any type of duress, that he's talking generally there. Now, between paragraphs 82 and 92 is the analysis about the existence of lawful act duress. That is to say, duress where it cannot be established that the threat is to do something which is unlawful as a matter of the governing law of the contract. And that's what you're looking at, to go back to the question that Lord Reid asked. You're looking at that conduct and asking, is that type of conduct unlawful as a matter of, here, English law? Now, at paragraphs 89 to 90, Lord Burroughs observes that in the light of the development of the law of duress, older cases that had previously been treated as ones of undue influence should be considered as falling within the umbrella of duress because the underlying elements were identical, namely the existence of an illegitimate threat. Now, that was so, as he explains at 90, even though those were not economic duress cases. So the cases that Lord Burroughs is referring to, Williams and Bailey, Mutual Finance and Kaufman, are in fact examples of what fall into Lord Hodges' first category of lawful act duress, to which I'll come in a moment. So in our submission, in Times Travel, the court was setting out certain unifying principles of the law of duress in the case of in the context of a claimed rescission. Now, if we can go back to in the judgment of Lord Hodge.
Yes, I would remember Lord Burroughs was a minority judgment.
Well, yes, but the majority agreed with those paragraphs. My Lord, that's very, sorry, I should have.
Yes, okay.
It's very important that, of course, I wouldn't be spending time on it, but if you go back to EF page 157, I'm only going to the paragraphs of Lord Burroughs with which agreement has been expressed. So if you go to paragraph 1 in the third sentence, I agree with what he says about, 1, the essential elements of duress, 78 to 80, existence in English law of the concept of lawful act duress, 82 to 92, and so on. And then again, 93, 94, 88, and so on. You can see. So those paragraphs, as I read the judgment, are effectively part of the majorities.
Yes.
I mean, Lord Hodge, in other words, Lord Hodge is saying we agree with all of that.
Yes.
And there's actually, the truth is, there was a narrow area of disagreement. It's important for our case, the area of disagreement, but because the area of disagreement related to the bad faith demand point, which I'm going to come on to, because that has significance for our case. But so on these essential, these critical points, there was in fact unanimity. Now, if we go back to paragraph 26 in it's Lord Hodge's judgment, but it's the judgment of the majority. Paragraph 26 at page 165, and I'm just giving you the pointers because I'm not going to read it out. Paragraph 26, the point that's being made is that there is in English law no doctrine of inequality of bargaining power. And so on page 166 at B, one sees after the reference to Barton and Armstrong, it said that in negotiating a commercial contract, each party to the negotiation seeks to obtain contractual entitlements which he or she does not possess unless and until the parties agree the terms of the contract. And then it goes on to explain why inequality of bargaining is not a feature of English law, so that the stronger party in negotiations might be able to impose terms on the weaker party which a party of equal bargaining power would refuse to countenance. That doesn't constitute, under our law, duress. I mean, one might say that's the hurly-burly of commercial life. Now, the next point I want to draw attention to is at 27. 27 is where it's made clear that English law has not recognised a general principle of good faith in contracting. So bad faith in contractual negotiations doesn't of itself constitute duress. Now, going forward at 28, one sees that there, the first sentence, the absence of these doctrines restricts the scope for lawful act economic duress in economic life. And then there is a reference to Professor Jack Beatson's book, The Use and Abuse of Unjust Enrichment, and that the text is quoted with approval. So what one gets from this is that there is no open textured or freestanding test of whether conduct is morally or socially unacceptable. And one way of looking at it is the court is not setting itself up as a court of morals. Now, there is there's a passage to similar effect in paragraph 95 of Lord Borough's judgment, with which the majority agreed. Perhaps if we go just pick that up for a moment. That is on page 188. And that's 95 is where he says that it's not appropriate to rely on a general principle of good faith dealing, in that would require a court to try and apply a standard of what is commercially unacceptable or unreasonable behaviour. Be a radical move for the English law of contract, and uncertainty not a price worth paying. And then at 94, again, don't need to read it out, but that's where the court, and the majority agreed with 94 as well, rejected the range.
Yes, that's. Yes.
So, my lord, the point I was making is that at 94, the court rejected the range of factors approach, which would have given a broad discretion to conclude that conduct was illegitimate or unacceptable in any particular case. Now, the majority at paragraph 30 said a successful case of lawful act duress will be very rare. Lord Burrows at 99 said it would be a rare exceptional case. So, my lord, the wide and open textured tests having been rejected, one comes back to the areas where duress, lawful act duress, has been recognised. Now, I acknowledge that in paragraph 3 of the majority judgment, it was said that the boundaries of the doctrine of lawful act duress are not fixed, but any extension needs to be approached with caution. And, my lord, it is, of course, striking. This was a major appeal heard very recently, where you were presented with a huge wealth of material relating to duress spanning over 100 years or more and from jurisdictions all over the world. And only 2 categories of lawful act duress have so far been recognised, as the judgment makes clear. Now, the starting point, it's at paragraph 4 that my Lord Hodge identifies the 2, but the starting point is in paragraph 2, and in particular, because paragraph 2 is where his lordship explains what the analysis shows and summarises it. And in the last sentence, it is explained that where duress has been recognised is where morally reprehensible behaviour, which in equity was judged to render the enforcement of a contract unconscionable in the context of undue influence. That's what has been treated as duress. And so at paragraph 4, Lord Hodge then sets out the 2 types of cases. Now, the first is where the defendant uses his knowledge of criminal activity by the claimant or a member of the claimant's close family to obtain a personal benefit from the claimant by the express or implicit threat to report the crime or initiate a prosecution. Now, my lord, it's clear that the facts of this case have nothing to do with that first category, which we can therefore put to one side. Now, paragraph 4 sets out then a second category. That is where the defendant, having exposed himself to a civil claim by the claimant, for example, for damages for breach of contract, deliberately manoeuvres the claimant into a position of vulnerability by means which the law regards as illegitimate and thereby forces the claimant to waive his claim. Now, my lords, there's a question which we'll come to as to whether that second category is engaged in this case or whether it provides a basis for Ukraine to reason by analogy. We say that's wrong, but we'll come back to it in due course. So, what one sees here is that there is no freestanding test of illegitimacy or unconscionability in determining whether there is lawful act duress, but a concept of illegitimacy can form part of or does form part of the second category. Now, at paragraphs 19 to 24, the court explains that these concepts set very high standards informed by the influence of the English law of equity.
I would have thought, Mr. Howard, that the concept of illegitimacy informs both categories, not just the second one.
Yes, I think that's right. Yes. But it's the first one is in a very specific circumstance. Now, it's worth noting in 19 to 24 that at 19, the court refers to Barton and Armstrong, which is the seminal case, one of the seminal cases on duress to person, and refers to it in the context of illegitimate pressure. You see that just before the quote. Now, what the court makes clear at this in the judgment is that whilst the categories of lawful act duress were not closed, it made clear what would not constitute lawful act duress. And there's an important passage for these purposes, which starts at paragraph 40 on page 171, EF 171, and that is at paragraph 40 and following, the court is analysing the CTN cash and carry case and the bad faith demand. And so what the court does at 43, it is explained what CTN is and isn't authority for. So its authority, as the first sentence says, for what is not such duress and for what is. Now, it's at this area that there's a disagreement with Lord Burrows, which Lord Hodge goes on to deal with. But at paragraphs 44 to 51, His Lordship is dealing with Lord Justice Staines' judgment in cash and carry, and essentially this is dealing with why a open-textured broad test is not appropriate and why a bad faith demand is not sufficient. So at 44, it's explained that the analysis which the court has made in the previous paragraphs is anchored in established legal principles, but essentially this broad approach, which it could be read into Lord Staines, was not. And the point is repeated at C on page 172 that there's no doctrine of inequality of bargaining power and so on. And at 46, Lord Hodge explains why this approach of a bad faith demand would extend the law, and at 45 to 48, and particularly 48, there's a recognition that what's called discreditable behaviour, in the second sentence of 48, can be a feature of commercial activity. And the important point is that the discreditable behaviour of itself is not sufficient to justify duress. And again, really what the court is saying there is purely because one thinks people may be behaving in a morally reprehensible way is not a sufficient ground to set aside a contract. And so at 49 to 51, 3 reasons are put forward as to why bad faith demands are not a sufficient basis for the law of duress. And one gets to 52, where the position is summarised, that I do not accept that the lawful act doctrine could be extended to a circumstance in which, without more, a commercial organisation exploits its strong bargaining power or monopoly position to extract a payment from another commercial organisation by an assertion in bad faith of a pre-existing legal entitlement which the other organisation believes or knows to be incorrect. And
that paragraph is important because all of this is occurring in the context of the relationships between two commercial organisations.
My Lord, that is right, and I'm going to come on to this argument that this doesn't apply because we're dealing with states here. I'll come to that. But this is dealing with a commercial transaction. Now, what the court was saying was that a general test of moral or social unacceptability is rejected. 2 limited categories of lawful act duress are recognised based on the 5 decided cases, but lawful act duress does not arise from discreditable behaviour or bad faith behaviour, or indeed even dishonest demands in the context of commercial contractual negotiations. So, my Lord, that takes me to the second topic, having seen that, is to look at Ukraine's case. Now, if I can briefly remind you, or give you the references. Ukraine's case, firstly, is summarized in the statements of facts, which you have in the at 8311 in Core Volume 1. At paragraph 6. So
I'm sorry, could you give me the page?
Yes, my Lord, it's MS 8311.
Thank you.
And it's paragraph 6, which is the summary of the pleaded case. Ukraine's pleaded case is the notes avoidable and have been avoided for duress. Ukraine contends, as summarized by the Court of Appeal at 8 to 9 and 164 and 166 of its judgment, that the Russian Federation applied massive, unlawful and illegitimate economic and political pressure, including threats to its territorial integrity and threats to the use of unlawful force. Now, the defence itself, your Lordships, we don't need to turn it up, you have the Court of Appeal judgment in Appendix Part 1 at 8639. If we could go to the defence, which is in MS 8823, and that's in the second core bundle. Your Lordships have the summary of the position at paragraph 2. And the relevant part for current purposes is at the bottom of page 8823, where it said, as part of that strategy, the Russian Federation applied massive, unlawful and illegitimate economic and political pressure to deter the administration led by Viktor Yanukovych from signing an association agreement with the European Union and to accept Russian financial support instead. And then it said the trustee and agency agreement were the fruit of that pressure. And the point about unlawful and illegitimate pressure is repeated at paragraph 4, and you can see it's including illegal trade restrictive measures and threats to Ukraine's territorial integrity and independence. Now, at paragraph 17 is an outline of Ukraine's duress complaint. And that goes through to, I think, paragraph 20 or 21. Now, if one asks, well, what were the threats what do they say? In paragraph 17, you can see the third sentence. One type, the steps included the imposition of unlawful trade restrictive measures on Ukraine, which are particularized below, as well as threats regarding the security of Ukraine's status as a sovereign state, including its territorial integrity. Now, all of these threats are said to have been threats which were made by the Russian Federation to Ukraine, in other words, sovereign state to sovereign state. Now, these threats are said not to have induced directly Ukraine to enter into the notes, but that they prevented Ukraine entering into the European Union Association Agreement, which put it into a position where if it needed to borrow money, its only potential lender was the Russian Federation. Now, at 18 is particulars of the trade restrictive measures, and they are set out, and I won't spend time on it now, but I'll just tell you at 18.1 to 18.4, They all concern Ukrainian goods being stopped at the Russian border and prevented from being brought into Russia. In other words, it just simply closing the border to Ukrainian goods. 18.5 is a threat to suspend gas supply. 18.6 is another allegation about border controls. 18.7 is an allegation to procure the bankruptcy of certain factories in eastern Ukraine. And then at 19, it's explained why these were illegitimate and unlawful. And the first thing is it said they were spurious and not applied for bona fide reasons. Now, I'll come back to that, but in the light of the Times Travel case, we would suggest that a bad faith demand isn't a foundation for a case of duress. But then at 19.2 and 19.3, it's alleged that these were in breach of various international treaties to which Ukraine and the Russian Federation are a party, and needless to say, none of those treaty obligations are incorporated into English domestic law. Now, at 20, then there are reference to threats, further threats, and 20.1 is a reference to further customs administration. 20.2 is a reference to annulling the free trade area and cancelling joint projects. And 20.3 is further trade measures. 20.4 is a reference to ceasing to cooperate with Ukraine on the production of some military equipment. 20.5 is a statement that if Ukraine enters into the EU association agreement, it won't be able to join the Eurasian Customs Union. And at 20.6 is a reference to protectionist measures. Then at 20.7 are various statements attributed to Mr. Glaziev at a conference. Now, the first one, again, deals with tariffs and trade checks. And then 20.7.2, we see the relevant threat is said to be that Russia could no longer guarantee Ukraine's status as a state and could possibly intervene if pro-Russian regions of the country appealed directly to Moscow. And then next is that at 20.8, Russia's supporting the Russian-speaking minority in Ukraine, and that Ukraine might be broken up as a result. 20.9 refers to a statement about having to restart discussions relating to the border. And then at 21, it said that these were illegitimate and unlawful because they either breached customary international law duties between Russia and Ukraine or treaty obligations. And at 71 of the pleading, the same theme is continued, where it said Russia made threats against Ukraine's territorial integrity and placed political, economic, and financial pressure on Ukraine, which then required it to borrow from Russia. So those are the nature of the allegations and why, on the pleadings, Ukraine says that what Russia threatened to do was unlawful or illegitimate, thus giving rise to a defence of duress. Now,
just on the causation point that Mr. Howard made earlier, could I ask the court to look at paragraph 72, so we don't need to go back to this document again, so page 8852.
Yeah, I wasn't suggesting, if that's what Mr. Thank you was indicating, that there's an issue for present purposes about causation. But anyway, there it is. That's what's said at 72. Now, my Lord.
Yep. So I don't understand that. I mean, all these threats and so on were directed to ensuring that Ukraine didn't go into an agreement with the European Association.
Yes, that's right.
Which then left them needing money, and the only place they could get money from was from you, from Russia.
Yeah, not from me personally.
Sorry. But you're saying that causation link, which is not an issue at all before.
The causation link is not an issue for today.
Is it an issue in the, I mean, if we upheld the Court of Appeal, is there then a causation issue?
There may well be. I mean, there are likely to be causation issues more generally as to in the case. But the current, for present purposes, my lord, we've got to remember we're at a summary judgment stage. So we're not seeking to challenge that aspect of the case for these purposes.
I'm just trying to understand, I understand it's not relevant for today, is what is in issue, assuming the case goes to trial, what will be the issues?
Well, I mean, there's likely to be issues about what was said. Nothing is agreed in this case about what was said, what was done. Going to have evidence from former President Yanukovych as to what he thought and so on. There are potentially a lot of issues.
Right. Okay, well, I better not go further into that.
My lord, now, if we then go to the Court of Appeal's judgment on this, which is in Core 2 at 8631, is where the judgment starts, and the relevant section that we're concerned with today is at 8667, where under the heading of duress, starting at paragraph 151, and the paragraph 151, I think, in part picks up the point that my lord was making. You'll see there at E what the Court of Appeal's analysis was, that according to Ukraine, there was a carrot and stick which were put into use in combination. Ukraine needed to borrow money. It hoped by entering into the association agreement to gain access to the European capital markets. Russia was unhappy with Ukraine entering into this association agreement and becoming close with the EU. Therefore, as well as making the threats, which are the foundation of Ukraine's case in duress, to dissuade it from entering into the association agreement, Russia sought to persuade Ukraine not to do so by agreeing to lend it 15 billion to help with its public finances. In other words, there were two things happening. One is, on Ukraine's case, do not enter into the EU association agreement. That may have bad consequences. But then there's a sweetener amongst, and the sweeteners were, we'll lend you $15 billion, plus we'll give you gas at discounted prices and various other things, which are set out in the pleading. Now, if we go forward to paragraph 155 of the Court of Appeal's judgment, there they outlined three issues, and we are presently concerned with issue 1, what they call the domestic foothold issue. And as summarised there, the question identified by the court was whether there was a domestic foothold for Ukraine's case that Russia's threats were unlawful as a matter of international law or otherwise illegitimate. And what the Court of Appeal noted at 156, which we say is entirely right, if there is no domestic foothold for the claims that Russia has breached international law or other international standards of behaviour, then there is no basis for a stay of proceedings or striking out the claim, because all of the allegations of breaches of international law are just irrelevant, and so Ukraine would have no arguable defence. Now, 157, the Court of Appeal identified the relevant test as a matter of English law, and what one sees is that they identified the test as being one of illegitimate pressure, which would depend on whether the conduct was morally or socially unacceptable. In other words, the Court of Appeal in this case was using the broad and unconstrained test for illegitimacy as it existed prior to this court's judgment in Times Travel. Now, what at 159, the court there said that there is a domestic foothold, but it doesn't say there is a domestic foothold for Ukraine's case that the threats were unlawful. Rather, it says that there was a domestic foothold in relation to the issue of illegitimate pressure. And that is explained in 160. And this 160 is clearly an important point. So, just going back to a question that Lord Hodge raised about times travel. So in times travel, yes, the court is dealing with commercial contracts. What here the Court of Appeal in this case is doing at 160 is saying, well, the law that we apply to commercial contracts essentially, or into a domestic setting, we apply to states, but we just have to tweak it a bit to try and work out what is meant by morally and socially unacceptable. So what you see is it said, it's true that Russia and Ukraine are sovereign states, which means that the test for what might count as morally or socially unacceptable in the context in which they interact is not the usual one appropriate to relations between private parties. But the authorities make it clear that the English law doctrine of duress doesn't turn on breach of domestic law as the criterion of illegitimate pressure. The notion of illegitimate pressure is wider than that. Although moral and social standards are more attenuated in the relations between states on the international plane than is the case in a purely domestic commercial context, international law sets out reasonably determinate standards of conduct applicable between states on the international plane. In our view, there's no reason why the law of duress should not treat these as providing an appropriate test of illegitimate pressure in the present case. So on the Court of Appeal's approach, at trial, the English court would need to determine the allegations of breach of international law, not under the heading of unlawfulness, but rather under the heading of whether the conduct of Russia was, as between states, morally or socially acceptable. Now, my lord, we say there are various flaws in that which we identified in our previous submissions. But even putting those aside, we say that this approach cannot withstand scrutiny in the light of times travel. So I turn to my third area of submission concerning the Court of Appeal's approach. Now, if one simply takes times travel on its face, in our submission, this court has rejected the open-ended test of whether conduct is morally and socially unacceptable. So if one applies to this case times travel, we suggest that the case cannot stand. Now, that takes one to the point that Ukraine makes, which Lord Hodge raised, which is, well, is this a commercial context? And in any event, and should you apply times travel to an interstate position? Now, you have undoubtedly seen this in Ukraine's further written case at, for instance, paragraphs 1.2.3, 1.3.1, paragraphs 3, 6, 15, and 16, where they seek to say this isn't a commercial context. Now, my lord, it is correct in one sense for Ukraine to characterize the allegations that it makes against the Russian Federation as allegations that arise on an interstate plane. But it is wrong to say, it's entirely wrong in our submission, that the present claim is not concerned with a commercial setting or a commercial transaction. The agreements that Ukraine seeks to impugn are quintessentially commercial agreements. They involve tradable notes listed on an international stock exchange that the parties have agreed are governed by English law. It is important also to note that the decision to use a commercial structure was that of Ukraine. And I should remind your lordships of the evidence on that, which is in Appendix Part 2, Volume 1, in the statement of Ms. Pakachuk of the Ukrainian Ministry of Finance, the statement starts at page 9, MS 9034, but the relevant part for these purposes is at 9055, at paragraph 63, where your lordship will see that she explained that it was Ukraine, it was for this reason that we proposed the deal should be structured through a commercial bond issue, since we'd already prepared papers for a capital markets bond issue since 2013 and had been updating these throughout. We could amend the drafts in order to...
Paragraph 64?
I beg your pardon? Paragraph 63, I'm sorry. Sorry, my lord.
Thank you.
We could amend the existing drafts to reflect the recent changes. I recall this proposal was put to Minister Siluanov, who then made contact with higher levels who'd agreed with the commercial structure as a way forward. Now, it is also worth reminding you of the Court of Appeal's judgment on a different point, but which is relevant for these purposes. In Core Volume 2, the Court of Appeal at MS 8693 and at 8693 to 8695, the court, well, the analysis actually starts at 8691. The lordships may recall, or you may or may not recall, because the matter isn't argued before your lordship, that Ukraine had alleged that certain terms were to be implied into the notes. The Court of Appeal dismissed that argument, as did Mr. Justice Blair, and there's no appeal to your lordships. But the analysis that the Court of Appeal puts forward as to why it would be inappropriate to imply terms, amongst other things, takes account of the tradable nature of the notes and so on. And it concludes at 8695, at letter F, that the agreements were contracts between Ukraine and Law Debenture relating to the issue and terms of tradable financial instruments. Given this reality, suggested terms are not necessary for business efficacy. But it's important to remember, as it so happens in this case, the Russian Federation was the original note holder and remained the note holder. But there was no certainty at any stage that that would happen. These were notes which could have been traded the very next day to institutions who, or indeed private parties who invest in such matters. So, my lord, the reasoning in those pages in our submission is equally applicable to an attempt to treat the notes as somehow not commercial. My lord, the fact that one of the parties to the agreements, Ukraine, may have entered into them for sovereign purposes or purposes relating to its dealings with Russia on the international plane is irrelevant to their proper characterization as a matter of English law. And your lordship are familiar with the sort of example that's given in Trentex, to which we referred to, a state going out to buy cement or boots for its military or whatever. Those, in one sense, are sovereign purposes, but those are the contracts it enters into are commercial contracts. It is also fair to point out that until the Times travel decision, which it obviously doesn't like, Ukraine's position was that when states choose to enter into commercial transactions, i.e. this one, they should expect to be held to the same standards of conduct expected of a commercial counterparty. I'm there quoting from their skeleton in the Court of Appeal at Appendix Part 2, Volume 2, MS 9395. What the argument here would amount to is suggesting that a commercial contract entered into by a state as a result of pressure by another state, should be subject to different and more stringent rules in relation to duress than commercial parties. In our submission, there is no warrant for that. Now, leaving aside the argument, therefore, that times travel doesn't apply in this to this type of transaction, Ukraine says that their case falls within the type of lawful act duress recognized by times travel, namely the second category. You'll see that in their written submissions at CF page 35, paragraph 17. Now, in our submission, that is obviously wrong. The second category requires that Party A exposes itself to a civil claim by Party B, for example, damages for breach of contract, and then deliberately maneuvers Party B into a position of vulnerability by means which the law regards as illegitimate, and thereby forces Party B to waive his claim. Now, my Lord, Russia didn't expose itself to a civil claim by Ukraine, which it then forced Ukraine to waive via the notes or indeed via any other agreement. And my Lord, this position actually is even more stark, because during the negotiations that led to the notes, there was a discussion between Russia and Ukraine about Ukraine waiving certain claims it might have against Russia in relation to the breakup of the former Soviet Union. And Ukraine resisted having to agree any such waiver. I won't take you to it, I'll just give you the reference, but it's again in Ms. Pakachuk's statement at Appendix Part 2, Volume 1, MS 9059, paragraphs 76 to 81. And none of the notes contain any waiver of pre-existing claims by Ukraine of any sort. So what does Ukraine say to that? They say, well, they should be treated as having, it should be treated as having waived claims it may have for a number of reasons, which it sets out in paragraph 15 of its written submissions. The first contention is that Ukraine believes itself unable to assert rights which it may have under international law against Russia, whether in the ICJ or the WTO or another international forum. Now, the straightforward and simple answer to this is that this is not a waiver of anything brought about by the entry into the notes. Ukraine may say that there have been breaches of international law, but the notes do not limit any rights which Ukraine may or may not have to pursue those claims in whatever international fora are available. Now, the second argument that Ukraine makes is to contend that it was forced, the way they put it, to waive its right to enter into the European Union Association Agreement. And my Lord, not entering into that agreement, by not entering into it, Ukraine wasn't giving up any existing legal right, simply never signed it. And there's a very significant difference between a party waiving an existing legal right and simply being pressured into contracting with another person. Indeed, this argument, if one pauses for a moment to think about it, drives a coach and horses through Lord Hodge's second type of recognized duress, because it would almost always be the case that a party subjected to some pressure whereby the party contracts with Party A would say, I waived my right to contract with Party B. Indeed, if one accepted this point, one would be essentially reverting to the position as it was before times travel and rejected in times travel. So in my submission, it is obvious that Ukraine's case doesn't fall within the second category of recognized duress as set out in times travel. And in our submission, not only doesn't it fall within that second category, but it in fact falls squarely within the type of case that the court in times travel expressly and definitively said does not constitute lawful act duress. Because, as we've seen, the court made it clear that bad faith and dishonest conduct in contractual negotiations by a party who exploits its strong bargaining position is not duress. But that in reality is the kernel of the complaint that Ukraine makes. Evidently, Russia is in a stronger bargaining position than Ukraine, and Ukraine was in the weaker bargaining position. And in that context, Ukraine says that the trade restrictions imposed by Russia were spurious and not applied for bona fide reasons, and that Russia threatened not to respect Ukraine's borders and that it could possibly intervene in its internal affairs with, it said, the deliberate intent of putting Ukraine under economic and political pressure. Now, in our submission, that conduct following time's travel is incapable of constituting duress. And so that what one then has to ask is, well, what is there about this case which it can be analogized to the two categories in time's travel, or allow the court to extend time's travel? Now, in our submission, there is nothing, and one can ask fairly, is the new category of lawful act duress, is there a new category of lawful act duress that has been defined? Now, in our submission, Ukraine hasn't made it clear in its submissions what it is. What are we left with? We've got that this case concerns alleged threats involving two states. Now, in our submission, nothing can turn on that, and I'll come back to this point in a moment. But in our submission, there are also a number of features of this case which underscore why this would not provide a basis for a new category of lawful act duress, even if one could be articulated. There are three I particularly want to highlight. First, the lawful act duress cases are concerned with a stronger party extracting something from the weaker party, whether by way of monetary payment or forcing the weaker party to give up an existing legal right. And it is fair to bear in mind, this case is concerned with precisely the opposite scenario, where Russia pays Ukraine $3 billion, which Ukraine refuses to pay. In our submission, it is difficult to see what the exploitation is in such a situation. The second point is Ukraine accepts it needed to borrow money from some source, even if it hadn't obtained it from Russia. And one sees that spread across the defense. So its real case is that it didn't like the fact that the lender was Russia as opposed to someone else. Now, the rate of interest that was charged was favorable compared to other rates relevant to Ukraine. It was 5%, and Mr. Justice Blair dealt with that in his judgment at paragraph 252, subparagraph 2, MS 8757. So what you're left with is Ukraine contends that some of the terms of the notes were unusual and onerous. Now, that allegation previously was considered or argued before you in the context of Ukraine's capacity and authority defense, and we rely on the submissions that we've already made and set out in writing in our written case at pages MS 8430 to 3. But Ukraine's argument on this was rejected by the Court of Appeal on the basis that terms of the type about which complaint were made are widely used, recognized and enforced in a variety of commercial and financial contexts. And that's paragraph 105 of the Court of Appeal's judgment. And we suggest that was an unsurprising conclusion when the terms about which Ukraine complains, namely a cross-default clause, a no-set-off clause, and a clause requiring Ukraine to maintain a GDP ratio that accorded with its own budget code, are not on their face objectionable. The third point we make, which I mentioned before, that this was an international bond issue governed by English law and subject to English jurisdiction to which the trustee was a party. And we would suggest it would introduce considerable uncertainty into English law to hold that such a bond issuance might be invalidated as a result of dealings between the issuer and another foreign state on the international plane. And one can think of many examples where a sovereign state issues a commercial bond and might then say that should be avoided because of conduct of another state. Is it enough that the bond was issued because of a border dispute or a trade dispute, which the issuing state says arises from unlawful conduct by another state as a matter of international law? If that was so, it has potentially very wide consequences. And Ukraine's arguments about duress have to hold good, even if the notes have been sold on the stock exchange to some commercial third-party buyer. But the overarching point I make is that the outcome for which Ukraine argues is directly inconsistent with what the court said in Times Travel about the need to keep the doctrine of lawful act duress within sensible bounds so as to protect the reasonable expectations of honest people when they enter into contracts. Moreover, it would be inconsistent with the rejection of the morally and socially unacceptable test and would effectively be reintroducing that rejected approach to interstate dealings, but not other dealings. My lords, that would be particularly surprising, as it would mean that for the purposes of the law of duress, firstly, English law is more willing to consider the lawfulness of a state's conduct than it is in other areas, and secondly, that the court adopted a less certain, more open-textured approach to state dealings than it did elsewhere. So our submission is that the effect of the Times Travel case is to undermine fatally Ukraine's case on duress, in addition to the points we've made previously. So that takes me to the next topic, which is the duress to person, duress to goods, and public policy arguments. Now, let's take duress to person first. So in the light of Times Travel, Ukraine's latest pivot of its case is to say that its duress defense is really only concerned, or is really concerned, with a threat of violence by Russia, and that all threats of violence constitute duress to person, and in this context, Ukraine does not need to show unlawfulness or illegitimacy at all. So Ukraine says at 1.2.1a of its further written submissions at EF page 26, in respect of duress to persons and goods, the court does not evaluate their legality as such. Such pressure, they say, is simply and obviously impermissible. So the case that is being presented to you is that provided Ukraine can classify the threats here as threats of violence to persons, then subject to issues of causation, duress is automatically established. Now, we would firstly say this is a radical recasting of the case. It would mean that Ukraine's allegations of unlawfulness and illegitimacy made in its defense in reliance on international law were redundant. It would also mean that the attempts by Mr. Justice Blair, the Court of Appeal, and indeed this court, to grapple with Ukraine's allegations in relation to the interstate nature of the dispute and its reliance on international law have all been entirely unnecessary and misdirected. Now, it would be, we suggest, quite surprising if Ukraine could, with one leap, escape all of the problems with its duress case by recasting it as a threat of violence and duress to persons. Now, in our submission, there are a number of reasons why, on the correct analysis, that purportedly easy way of avoiding all the difficult issues in this case is not open to Ukraine. The first point is this. As is evident from Ukraine's defense, the threats that it alleges occurred and on which it relies were all threats by Russia, by the Russian Federation, against Ukraine in its capacity as a state. I've shown you how those threats are framed in the defense itself. They concern political and economic pressure being placed by one state on another in the context of their international relations. Indeed, that is precisely how they are described in the Statement of Facts and Issues at paragraph 6 at MS 8311. Now, as we considered a short moment ago, in the context of lawful act duress, Ukraine repeatedly affirms in its written submissions that the matters on which it relies relate to an interstate dispute or interstate dealings between Ukraine and the Russian Federation. Consistently with the allegations Ukraine has made and how it has characterized them, those threats are said by Ukraine in its defense to be unlawful or illegitimate, not by reference to standards that apply to the treatment of persons or goods under domestic law, but instead by reference to standards that apply between states on the international plane, namely international law. The threats on which Ukraine relies are not threats to harm particular people or particular goods, and are instead of an entirely different type, namely threats to the economic and political interests of the state of Ukraine. Indeed, the threats on which Ukraine relies that Russia threatened to intervene in Ukraine to support what Ukraine itself describes as pro-Russian regions of the country, that you see it in their defense at 20.7.2 in MS 8833, and Ukraine's Russian-speaking minority, that's 20.8 of MS 8834. Now, these are not, even on Ukraine's case, threats to murder civilians or to harm civilians or to loot and plunder their property. Rather, they are threats between one state and another to the other's territorial, political and economic interests as a sovereign state. Lord, stand back for a moment. Even if it could be said that Russia threatened war, and we say that can't sensibly be derived from the threats on which Ukraine relies, but let's assume against this it could. Such an international armed conflict would not be one to which the ordinary rules of domestic law apply. It would remain a threat on the international plane, governed by international law. It is not one subject to domestic law or analogous in any way to a threat of violence to particular people that would be contrary to domestic law. And indeed, this court made clear in Belhaj that acts of war by one state against another are the quintessential acts that are not governed by domestic law and on which domestic courts should not adjudicate, but rather play out and are regulated, if at all, on the international plane. If I can just remind you of Belhaj, which is in volume 1 of the authorities, and at tab 1, and it's MS 18.
The page reference, please. Electronic bundle.
Yes, it's
MS 18.
MS 18 is where the judgment starts.
Right, thank you.
And the relevant passages, if we go to MS 162, in the judgment first of Lord Mance at 107.3, where he says that if violation of a jus cogens were a primary test of whether a domestic court...
Sorry, where are we again?
I'm sorry, my lord. MS 162. It's page...
Yeah.
It's
Subparagraph 3, is it?
It's paragraph 107, subparagraph Roman 3, the paragraph at the foot of the page. if violation of a jus cogens were a primary test of whether a domestic court could adjudicate upon an issue which was otherwise non-justiciable and upon which it could otherwise have to abstain from adjudicating, central areas of abstention identified by Lord Sumption would become potentially amenable to adjudication. The prohibition on the use of armed force and on aggression are core examples of jus cogens, yet these are rightly, as would be my present view, treated by Lord Sumption himself as giving rise to core examples of issues upon which domestic courts should refrain from adjudicating. And at 165, Lord Neuberger, at paragraph 123, one sees he makes the same point. The third rule has more than one component, but each component involves issues which are inappropriate for the courts of the United Kingdom to resolve because they involve a challenge to the lawfulness of the act of a foreign state, which is of such a nature a municipal judge cannot or ought not to rule on it. Thus, the courts of the country will not interpret or question dealings between foreign sovereign states. Obvious examples are making war and peace, making treaties with foreign sovereigns, and annexations and cessions of territory, per Lord Pearson in Nissan and the Attorney General. Nissan was concerned with Crown Act of State, which is of course a different doctrine and considered in Mohammed Serdar, but the remark is nonetheless equally apposite to the Foreign Act of State doctrine. Similarly, the courts of this country will not, as a matter of judicial policy, determine the legality of acts of a foreign government in the conduct of foreign affairs. It's part of this rule that international treaties and conventions which have not become incorporated into domestic law cannot be the source of domestic rights of duties and will not be interpreted by our courts. This third rule is justified on the ground that domestic courts should not normally determine issues that are only really appropriate for diplomatic or similar channels. And then finally, Lord Sumption.
May I have that the paragraph number of Lord Neuberger, please? I'm so sorry.
I'm sorry, my lord. 123 starts at MS 165.
123, thank you. Thank you.
And then Lord Sumption is at MS 205. It actually starts at 204 at paragraph 234. So it's probably worth picking it up there. The second principle, which can conveniently be called International Law Act of State, corresponds to the variety of foreign act of state identified in the judgment of Lord Mance at 11.3c. It's that the English court will not adjudicate on the lawfulness of the extraterritorial effect of foreign states in their dealings with other states or the subjects of other states. And at the top of the next page, after the reference to the authorities, this is because once such acts are classified as acts of state, an English court regards them as being done on the plane of international law, and their lawfulness can only be judged by that law. It's not for an English court to apply international law to the relations between states, since it cannot give rise to private rights or obligations, nor may it subject the sovereign acts of a foreign state to its own rules of municipal law, or by the same token to the municipal law of a third country. And at letter D, if a foreign state deploys force on in international space or on the territory of another state, it would be extraordinary for an English court to treat these operations as mere private law torts, giving rise to civil liabilities for personal injury, trespass, conversion, and the like. This is not for reasons peculiar to armed conflict, which is no more than an ill-defined extreme of interstate relations. The rule is altogether more general. Once the acts alleged are such as to bring the issues into the area of international dispute, the act of state doctrine is engaged. And he returns to that at 237 on page 206.
Mr. Howard, I'd understood that you were no longer relying on this head of Butte's gas non-justiciability. Is your point, the point that you're now making, a different one, that such situations cannot be assimilated to torts in municipal law?
Well, we say they can't be, exactly, they can't be assimilated to torts, and so you can't equally treat this as, well, sorry, the fundamental point I make is that what is sought to be done here is to assess Russia's conduct on the international plane. What we submit is that is, as it were, a no-go area, unless you fall within one of the exceptions. And
well, I'd understood that you were no longer pursuing that.
Well,
you identified two types of non-justiciability.
Yes.
One, you say, is the relevance issue, and the other is the suitability issue.
yes.
Which are helpful tags. And I understood you were no longer relying on the suitability issue.
Well, my Lord, in the context that we're now talking about, which is duress to persons, so what is being said is that one can recategorize the case as one of duress to persons and treat the alleged threats by Russia as if they were a threat to individuals somehow. And we say we say you can't do that because the threats that are being spoken about are matters which arise on the international plane, and you can't repackage them and say, well, we can somehow treat that as being on a domestic plane.
Yes, thank you.
I hope that answers Your Lordship's question. I think perhaps I think I haven't properly explained it. The point, my Lord, is this, that what Ukraine is saying, if you look at the threat, so you have a threat here which is said to be a threat that, we say it doesn't amount to that, but let's say it did, that Russia is threatening to go to war with Ukraine. The question is, for the purposes of the law of duress, can the English court ever assess that matter? I mean, both as to whether it's lawful, but is it even something which enters into the equation? What we're saying is there's a difference between threats on the international plane, or a state doing something on the international plane, and something on the domestic plane. And here, all that's being said is these are interstate dealings. And we say that they're not capable, without more, of amounting to something which actually is relevant on the domestic plane.
I think you may be agreeing with what I put to you initially, which was that it's simply that you cannot assimilate such conduct on the international plane to duress against the person or the rest of it.
Yes, that is my position. Yes. That's why I was slightly concerned.
My question then is, how do you reconcile that with the fact that, as I understand it, you are no longer relying on Butte's gas non-justiciability?
Well, my Lord, in this, remember that we're dealing with a different point now, which is whether you can categorize the threat as a duress to person threat. What we're saying is that it would be very strange to simply if you take a situation of one state, say going to war with another, let's say it actually does go to war, that you can sidestep what is being said in Belhaj and has been said for a long time by saying, well, we treat that not as interstate conduct, but simply a tort where individuals are getting injured. And we're saying part of what is being said here is that you simply can't look at it like that, because this is all up on the international plane. And so if you're analysing the threat that's being made here, it isn't a threat that can be analysed as a threat to persons as it would be understood in English law.
I'm still unclear as to how that sits comfortably alongside the position you take in relation to the case as previously advanced.
Well, I don't think it's inconsistent.
Anyway, the position is that so far as this way in which duress is put, you are relying on Buttes-Gas non-justiciability.
Yes, we're relying on, well, we're relying on that you haven't got a threat on the domestic plane. And what we're saying is you've got to have a threat which can be recognised as a matter of domestic law. And a threat on the international plane isn't something that you could recognise as a matter of domestic law.
Thank you.
Sorry, I'm sort of having trouble with this. Why is that different in relation to a threat duress to person than it is to duress generally?
Well, the case that we've previously been dealing with is that the threats, the political economic threats, were ones which the English court can adjudicate on because they fall within the moral and socially acceptable. Our submission is you can't do that because you're seeking to use international law inappropriately. But this aspect of the case is...
But I mean, are you saying you do or you don't need Buttes-Gas for that?
Well, we say we don't need Buttes-Gas, I think, for that. That's the position. Well, so I wasn't seeking to go back on the arguments that we have previously made. What I think there may be a confusion. I mean, there's, as Your Lordship says, I've dislodged my contact lens. I'm sorry. I think I can manage with one eye.
If you need an adjournment for a moment, Mr. Howard.
Would Your Lordship mind, because it's very distracting. I'm sorry.
I hope you're more comfortable now, Mr.
Yeah, I'm grateful for Your Lordship's indulgence. I'm pleased to say I can see you all now. My Lord, and if I can just try and to make clear my submission and what the point was that I'm making. What we're concerned with when we get to the duress to persons case is whether the threats that are alleged, and the first point is, do they constitute threats to persons? And that's the point I'm making. It's not going back on Buttes-Gas. The reason I was referring you to Belhage is recognising what the English law says about the English courts not going into this area of interstate disputes. If you then say, well, where there's a threat to go to war, that necessarily is a threat against a person, and that's something that the English court would treat as a threat against a person, that we say would simply undermine that whole jurisprudence, because it's simply saying I can ignore the fact that we have all this approach about things on the interstate plane and simply repackage it as saying, well, any act of war is going to injure individuals, and so it's a threat to individuals or if you like, a tort. And that's all we're saying at this stage, is that if you're analysing the threats, they're not what English law, when you look at the cases about threats to persons, they're about wrongfully imprisoning somebody or threatening, A threatens to kill or harm B. They're not, this is not that threat where you have dealings between states. That's the point of showing you that authority. The second point I make is that it must, we submit, always be established, at the very least, that the threat is illegitimate. So that, we say, is clear from the statement of general principle in Times Travel, in the judgment of Lord Burroughs, which I went to earlier. And we suggest that there are no areas of law of duress that have been hived off where, to show that particular types of threats do not need to be shown to be illegitimate or automatically treated as illegitimacy. And so just looking at, for instance, taking Ukraine's case of saying, well, there's a threat of violence, so that necessarily leads you to say that that must be illegitimate, in our submission doesn't assist. What the court has to do is look at the threat that is alleged and ask whether that threat is unlawful or illegitimate. And once that is acknowledged, then repackaging the case as duress to persons, which we say can't be done anyway, doesn't assist, because you come back to the same question. Because if you have to consider unlawfulness or illegitimacy, then you come back to the same point, that unlawfulness under international law is not part of English law, and illegitimacy doesn't arise because there's no conduct that falls within the court's reasoning in Times Travel, and in any event, you cannot use international law, for the reasons we've previously submitted, as the yardstick for legitimacy of a state's conduct.
Does this really mean that the doctrine of duress cannot apply to a contract between states?
No. It depends on the facts. So, I mean, an example that Mr. Thankey is fond of, what if the president of Russia or his bodyguard holds a gun to the head of the president of Ukraine? Now, in that situation, you've got something which is not, as it were, on the international plane. That is directly a threat to person, and English law would say, well, that is simply a threat to kill the president, and therefore, that was the operative threat. Therefore, we would accept that that is an area where it wouldn't be any different. But you can't treat, we would respectfully say, interstate dealings where one state may be expressly or implicitly, for instance, threatening the borders of another, as therefore that amounts to a threat to persons in the state. And if one thinks about that, I mean, practically any dealings between states where obviously you have, well, you could take the current dispute that goes on between is going on between the United Kingdom and France relating to shipping. Now, no, to fishing rather. Now, obviously, we're not going to go to war with France, or at least I hope we're not, over something like that. But you could see a situation where it's not so, I think within all our living memory, there were gunships, I think, at one point 20 or 30 years ago. But if you have that sort of situation, it would be ridiculous to say, well, there's an implicit threat that if you don't agree with us that we'll go to war, and that somehow is something that the court could take into account.
Mr. Howard, I don't want to take you out of your order, but you said a moment ago that, as I understood it, that one reason why illegality in international law could not be relied upon was because it wasn't part of domestic law.
Yes.
And at some point I'd be grateful if you could deal with this question, which is whether it's necessary for international law to be part of domestic law in this jurisdiction in order that the unlawful character of conduct could nevertheless be relied upon in proceedings here?
Well, Lord, the answer to that is, generally, it depends really on the circumstances of the case. I don't think one can give, as it were, a blanket answer to say that there is no circumstance. I mean, clearly we see cases where the English courts have considered matters, and that takes you back to you've got the relevance and suitability questions, which we've previously identified. So we're not saying necessarily every single case you couldn't consider matters of international law, but on the whole, the answer is, I mean, particularly where we're talking about the law of duress and a threat that's alleged to be made, yes. In our submission, you can't consider that.
Well, no doubt you'll come to it, but I'd be grateful if you could explain at that point why it's a necessary step for you to, why it would be necessary for the rule of international law to be a rule of domestic, to be accepted as a rule of domestic law.
So why it would be necessary?
Yes.
Well,
in order that it could be relied upon by this court.
Well, my lord,
is it not possible for domestic law to refer to the position in international law without that law being part of domestic law?
Well, I think that you've got to remember we've got to go back to the law of duress here. That's the starting point with respect. The starting point is that what we're concerned with is conduct, firstly, which is unlawful as a matter of domestic law or illegitimate as a matter of domestic law. That's the test for duress. And so then the conduct on the international plane is not unlawful as a matter of domestic law if it isn't incorporated in international law. And that's why the Court of Appeal proceeded on the basis of just trying to see whether we can treat it as illegitimate for purposes of English law. And that's what that was their judgment. Now, we say Times Travel has abandoned this sort of broad test of illegitimacy, and that you've got actually a very narrow scope for duress. So once you recognise you have that very narrow scope, once you're considering illegitimacy, simply saying, can I look at conduct on the international plane, doesn't really inform you, because what are you looking at it for? For instance, if you remember what was being said in Times Travel, between commercial parties, the mere fact that one behaves in a disreputable or dishonourable way and takes advantage of the other, that's not something we go into. We're not a court of morals, effectively. Now, equally, when you're looking at a state, simply saying, well, one state has bullied the other by, for instance, threatening territorial integrity, our main submission is, so what? That's not conduct which is capable of amounting to duress, because it's not sufficient simply to say, well, that's a breach of international law obligations. You've actually got to bring yourself within the Times Travel approach. But we also say that it would be wrong anyway for the English court to be treating those matters as relevant for English law when it is not treating them as part of English law and unlawful for English law.
I can see that the effect of Times Travel may well be to limit the scope of lawful act duress. What's troubling me at the moment is the question whether in the context of unlawful act duress it's permissible or possibly required for a court in this jurisdiction to have regard to illegality in international law.
Well, in my submission, it's not a question of having regard to, it's a question of, is the matter that is complained of illegal, unlawful as a matter of domestic law? So if you take the Dimskull situation...
It comes back to Dimskull, should it?
It does come back to Dimskull. I mean, if it's lawful in Sweden, we don't take any account of that because that conduct is regarded as unlawful in England. Conversely, if it were unlawful in Sweden but lawful in England, we don't take any notice of it. Now, in our submission, international law is the same. You don't incorporate or take account of a foreign law for the purposes of the law of duress. You're only interested in unlawfulness of a threat or illegitimacy of a threat as a matter of English law. Now, the way that the Court of Appeal were approaching it under the prior law, one can see that there was more scope to say that when considering illegitimacy, we can take account of international law because we're not treating it as part of domestic law, but it provides a yardstick. But once one sees that illegitimacy within times travel is actually a very narrow concept, in our submission there isn't any room for doing that. Now, the current submission I'm dealing with, of course, is the duress to person point, and so it incorporates all of that. My first point was, well, there isn't actually a threat to persons. My next point is that, anyway, as a matter of English law, the threats have got to be unlawful or illegitimate. In other words, there isn't, you can't simply say that there was a threat of violence. Now, I'm slightly running out of time, my lord, so can I just give you the references? We rely on Cheshire and Firefoot, which is at EF 268, tab 240, at page 271, where they say the threat must be illegal in the sense it must be a threat to commit a crime or a tort. Tritle says something to similar effect. An example of this is in... Could you
give us the reference to Tritle?
Tritle, my lord, is at EF page 274, tab 241, and see page 276.
Thank you.
At 10-006. And an example of a case which is a case which they refer to as Smith and Monteith, which is in the Supplementary Authorities Bundle, which is Supplementary EF at page 92, which concerned imprisonment of somebody, and the Lord Chief Baron Pollock found that the contract was enforceable because the arrest was lawful, and Baron Park reached the same conclusion, and you see that at 439 and 442 of the report. And so if you consider, just by way of analogy, a person who owns a business who's under pressure because the authorities are prosecuting him and he fears being put in prison and losing his business, and therefore sells his business at a discount to a purchaser who is aware of the difficulties he is under and seeks to exploit it for his own advantage. In other words, seeks to buy the business at a knockdown price because he knows the person fears being imprisoned. Now, in our submission, it's clear from Times Travel that would not allow the setting aside of the contract for duress, because all that's happened is one party has taken advantage of somebody. It might be morally reprehensible or not, but it's not sufficient to bring oneself within Times Travel. And you can't say, well, because it was somebody who feared being put in prison, that makes the difference. So we say it's artificial to say that because you could try to characterize the threats as threats to duress to person or threats of violence, that somehow takes you out of the requirement for unlawful or illegitimacy. Now, Ukraine has referred to authorities relating to suicide, and what's the position where somebody threatens to commit suicide. Now, in our submission, suicide is it gives rise to different policy considerations. Your Lordships will recall that it was only in the 1960s that suicide ceased to be a crime, and so it would potentially give rise to different issues. We would suggest that suicide, a threat to commit suicide, may well fall within the first category, of Lord Hodges' analysis. But in any event, it is a sui generis area that can't be used as a beachhead to justify a radical proposition that whenever there is a threat to person, it's not necessary to show unlawfulness or illegitimacy. Now, if I can just briefly deal with the two other points. Duress to goods, we submit, firstly, this isn't a case of duress to goods at all. The Russian Federation saying, I'm not going to let your goods in, is not duress to goods. It's not exercising dominion over somebody else's goods. It's not duress to goods to refuse to buy somebody's goods or to refuse to allow them to be imported into your country. So as well as there being a need for illegitimacy and unlawfulness, we say the case simply doesn't get off the ground. So Ukraine's final pivot is to rely on public policy, some of which we've previously seen and some of which has come up in a different guise. So they rely on two cases. One is the Royal Bexalis case, and the other is Kuwait Airways. Now, the Royal Bexalis case, you'll remember, is a case in which concerned Iraq, where Saddam Hussein was using people as a human shield. And in our submission, that is a straightforward case of duress to persons and duress to goods. It involved Iraqi officials refusing to permit the evacuation of particular people from Iraq and refusing to permit the plaintiffs to remove their property from Iraq. Duress to persons and duress to goods was pleaded, and it wasn't in dispute that duress was made out. And you see that in our authorities, it's at Volume 3, MS 1149, and you see that it wasn't in dispute that duress was made out at 1164, at paragraph C in Lord Justice Stuart Smith, and 1170 in Lord Justice Pill at 695D. And it isn't a case, as Ukraine suggests, where the court concluded that international law obligations informed English public policy. That doesn't feature anywhere in the judgment. Ukraine relies upon what Lord Justice Phillips says at page MS 1204 of the report. What Lord Justice Phillips was dealing with was a different situation, which was one where the parties choose a governing law for their contract other than English law, and there was a question whether the conduct was so egregious that the court should ignore the governing law. So in that case, the argument was that or at least the question that was being considered was, even if the governing law wouldn't regard this as duress, do we, as a matter of English public policy, look at what happened and say we won't enforce it? Very different to the question here. Kuwait, as you know, is not a contract case at all. It was a tort claim relating to misappropriation of the plaintiff's aircraft. And what the case concerned was the disapplication of Iraqi law. Iraqi law would have made the expropriation lawful, and normally Iraqi law would apply, and it was disapplied, amongst other things, and we've seen this. The Security Council had declared that Iraq's conduct was unlawful, and there was a Security Council resolution. The simple point about that is, A, it's very different to our case. B, this is not a case, if we look at the conduct which is complained of here, the threats, which have been universally condemned in the international community. There is no Security Council resolution or anything of that sort. Indeed, the most that Ukraine is able to point to is that the threats to impose restrictive trade measures was criticised by the European Union, which is unsurprising, bearing in mind the European Union was seeking to bring Ukraine into its orbit, and Russia was seeking to bring it into its orbit. So in our submission, that is neither here nor there. The final point just in this area to point out is that it is irrelevant in our submission whether the international law obligations on which Ukraine relies are rules of jus cogens or not. The fact that there is an obligation of jus cogens doesn't make it any more likely to be incorporated as part of English law. We've given your lordships an article by Sir Michael Wood, which is at EF page 278, where he suggests that a breach of jus cogens, it's not a breach of jus cogens to threaten the unlawful use of force. Now, Ukraine has put forward a competing view from somebody called Nicholas Stöckler, which is in the supplemental EF at page 129. Now, your lordships don't have to resolve this point. I think it's simply sufficient to know that it's certainly not common ground or universally accepted.
It doesn't matter, does it, Mr.
No, no.
Whether something's a rule of jus cogens is simply a question of whether derogation is permitted from such a rule.
Yes. Yes.
It's something that originates in the law treaties.
My Lord, that's right. The only reason I'm making the point is it has arisen.
I don't think it touches on the
appeals judgment.
issues.
Yeah. So, my Lord, sorry, I slightly overshot, for which I apologise, but those are our submissions, and in the light of the Times travel judgment, as well as our prior submissions, we submit that Ukraine does not have an arguable case on duress.
Thank you very much, Mr. Howard.
My Lord, I should have said Mr. Jones is participating, but he's actually moved back to Australia, so he's watching online, but obviously you can't call on him.
When he's having a late night.
He is.
My Lords, I'm going to go slightly out of order just to knock one point on the head, which is this question of physical duress. It's a very surprising contention by Russia that we haven't pleaded the threat of physical duress, or that there's some sort of pivot or radical realignment of our case. And can I just ask the court to take up Core Volume 2, because this is actually has always been the central part of our case, and indeed was the core part of Mr. Justice Blair's judgment, and even more importantly, in the Court of Appeal. If one could go, please, to Core Volume 2, MS 8766, in the judgment of Mr. Justice Blair. At the foot of 8766, if the court has that, at paragraph 308, and Mr. Justice Blair begins, the court's conclusions are as follows, and the four critical paragraphs, which the Court of Appeal proceed on the basis of, are subparagraphs 1 to 4, and one is, the trustee tended to diminish the significance of these threats, that's the threat of force, in oral argument. However, as Ukraine rightly says, the threat of the use of force in 2013 has to be seen against the actual use of force in 2014. That's the Crimean invasion. Further, it says that the lack of evidence of direct government-to-government threats has to be seen against the fact that the senior members of the Ukrainian government fled to Russia in 2014. The court sees no reason not to accept these points. And then this, critically, subparagraph 2, in English law, violence to a person or threats of such violence have long been recognised as a paradigm form of duress, entitling the victim to avoid a contract entered into as a result. And he cites a passage from Chitty. If the same approach is applied to Ukraine's defence, its case is plainly a strong one, particularly on a summary judgment application. And then at 3, the trustee's answer he deals with there. And then subparagraph 4, the first question is whether there's sufficient factual foundation for a decision as to justiciability on the summary judgment application, refers to Belhaj. There is such a foundation because Ukrainian's case as to the threats made is credible and has not been answered. So Mr. Justice Blair has there found a threat of violence, i.e. duress to the person, that has never been appealed or contradicted. And indeed, when one looks at the Russian the Russian case, they seem to suggest, this is paragraph 8 of my learned friend's reply, that we should have identified as specific citizens in Lviv or a specific tractor factory in Dnipro that was threatened by Russia, and that is just assertion and is wrong. What is alleged here is a threat of force, and one can't shy away from what a threat of force means. It means a threat of invasion, threat to people, threat to citizens of Ukraine. I'll come back to this point. It's slightly out of the order in which I wanted to take things, but it's important. And if we go to the Court of Appeal, having seen that the judge had no difficulty in discerning allegations of threats of violence, and the relevant part of Chitty that the learned judge referred to was duress to person in that edition of Chitty. If we then go back to the Court of Appeal in the same volume, at MS 8672, and then at the foot of 8672, at paragraph 164 in the Court of Appeal's judgment, saying, despite there being a domestic foothold but for reference to Russia's obligations under international law in relation to Ukraine, is there some supervening reason why Ukraine's plea of duress, invoking as it does alleged breaches of those obligations, should not be treated as justiciable by domestic courts? For the purpose of Ukraine's resistance to summary judgment being entered against it, the judge found there is sufficient factual foundation for Ukraine's allegation of duress by reference to an alleged threat to use force against it and its territorial integrity if it did not repudiate the draft EU association agreement and enter into the notes instead. And one sees there that the Court of Appeal notes the specific paragraphs in Mr. Justice Blair's judgment that I've just shown the Court, paragraphs 308, 1 to 4. This finding, so far as it is relevant for purposes of Law Debenture's claim for summary judgment, has not been put in issue on this appeal. See that this finding of a threat of violence or physical duress is not in issue, as the Court of Appeal records, and wasn't challenged. Now, going back to where I had intended to start, which was times travel, Mr. Howard has very helpfully dealt with a number of passages, so I won't need to go over some of the material. But perhaps we could just start with, so this is in EF 154 at Supplemental Authorities tab 236. And perhaps we can start with the 4 common ground paragraphs in Lord Burroughs at 202.
Which paragraph?
It's paragraph 136 in Times Travel. And
EF 202, I think.
it's page EF 202. And subparagraphs 1 to 4 were common ground referred to in Lord Hodges' paragraph 1. The rest of this is not common ground, but 1 to 4 were. And we make 3 overarching submissions on Times Travel. And first of all, if one glances at the subparagraphs, the minimum requirements for all forms of pressure remains one of illegitimacy. And that's the point. One sees that referred to in subparagraph 2, minimum requirement illegitimate threat, subparagraph 3, illegitimacy again. And that is an application of the Universe Sentinel and indeed Barton and Armstrong. The second point we make on Times Travel is that the narrow scope for lawful act illegitimacy set out in Times Travel is confined to cases where the pressure is economic in nature. It doesn't purport to apply to cases of physical duress or duress to property. And I'll come back to that. The short point we make is that English law regards the threat of violence to procure a contract as illegitimate. And John Cartwright, in his seminal work, Unequal Bargaining, we don't have it in the bundle, but he makes the point there has never really been any analysis as to why that's the case. It's just treated as illegitimate, full stop, a threat of violence to procure a contract. But I'll come back to my point that there is no requirement of technical unlawfulness where duress to the person or duress to property is concerned. And where the threat of violence comes from a state, whether the court will adjudicate the issue requires the application of the Foreign Act of State principle. The identity of the maker of the threat does not make the threat illegitimate or legitimate. That is a question for the Foreign Act of State principle to determine. The third point we make is that if necessary, Ukraine can bring itself within a principled application of Times Travel Category 2, or, and remembering always that this is a summary judgment application, Ukraine's case involves an arguable incremental development of Category 2, as to which, as my learned friend pointed out, the Supreme Court has made clear that the boundaries of lawful act duress are not closed. My Lord Hodge at paragraph 3. So those are our three overarching points. Now, the third point, Times Travel Category 2, is premised on the assumption that lawful act duress is in play here. The court already has our submissions that we can rely on Russian conduct which is unlawful or illegitimate by reference to English law standards alone, including public policy, and/or we are entitled to rely on particularly egregious breaches of international law by Russia to show illegitimacy and to show that there is no reason to apply anything other than the ordinary standards of the law of duress to a state on the facts of this case. And the court also has our submission that if the English court is precluded from considering our defence by the application of the Foreign Act of State principle, the appropriate course is to stay Russia's claim rather than simply giving judgment in its favour without reference to Ukraine's defence. And one sees the way the Court of Appeal dealt with this below. I won't turn it up, but it's paragraphs 182 to 186, MS 8680 to 81, applying Butte's gas and the Shergill and Kyra cases, which we spent some time on at the last round of this hearing. Now, in relation to the point that the Times Travel case is confined to the context of economic duress, did not concern duress to the person or duress to property, can I just draw the court's attention, first of all, to Lord Burroughs, if you still have Times Travel to hand, it's EF 176. Paragraph 62.
Which paragraph?
62, my lord. At page EF 176. And at 62, Lord Burroughs makes the point at the outset that duress in the law of contract focuses on illegitimate threat or illegitimate pressure. And then just above letter H, in this case, we are concerned with that form of duress that has been labelled economic duress. And the rationale for that, if one goes on to paragraph 136, subparagraph 4 of EF 202, the rationale at subparagraph 4 is that a demand motivated...
Sorry, subparagraph 4 of...
136, subparagraph 4 on page 202.
Yeah, I'm working from a different copy. Which paragraph?
136.
Thank you.
I'm sorry, my lord.
Thank you very much. My fault entirely.
And subparagraph 4, a demand motivated by commercial self-interest is in general justified. Lawful act economic duress is essentially concerned with identifying rare, exceptional cases, etc. And the rationale for Lord Borough's approach, just similar to the majority, one goes back to paragraph 97. To 99, but at 97, his lordship makes the point that in the context of lawful act economic duress, it's clear that in general a demand motivated by commercial self-interest is justified. And then at 99 over the page, letter E, the doctrine of lawful act economic duress is essentially concerned with identifying rare exceptional cases where a demand motivated by commercial self-interest is nevertheless unjustified. And then if we go to my Lord Hodges' judgment, paragraph 57, EF 175, right at the end, Lord Hodge says that the scope for lawful act economic duress is extremely limited in the sphere of commercial transactions. So again, we're in the realm of economic duress. And essentially the same rationale as Lord Borough's is given. If we go back, please, to paragraphs 26 through to paragraph 30, and at 26, the reference Mr. Howard took you to, the first point is that in English common law, there's no doctrine of inequality of bargaining power in contract. Second point, paragraph 27, between letters E and F, in contrast to many civil law jurisdictions and some common law jurisdictions, English laws never recognise a general principle of good faith in contracting. And then paragraph 28, the absence of these doctrines, i.e. the two doctrines we've just looked at, the absence of these doctrines restricts the scope for lawful act economic duress in commercial life. So again, we're in the realm of economic pressure. And we say that the rationale is not applicable where the threats are non-commercial in nature. And if one goes to Lord Hodge at paragraph 33, this is dealing with other jurisdictions, but this is quite a good example. If we go to paragraph 33, and we can take this at page 168, where there's a citation from Edelman and Bant on unjust enrichment. Just above letter C, where the threatened conduct is non-commercial in nature, and then the examples are given such as threats to publish information or threats to foster rumours about a company, a finding that the threat is disproportionate and therefore illegitimate may be more readily made. And then my Lord Hodge makes the point that disproportionality is not part of our test. But at letter D, my Lord says that the author's recognition that there might be scope for non-commercial threats to fall within the doctrine of lawful act duress is salutary, as the control of such threats by the common law would not cut against the grain of statutory regulation or unfair contract terms or consumer contracts. And that it's certainly not the case where the threats are to life and limb, i.e. physical duress. Non-commercial threats do not cut against the grain of statutory regulation. And indeed, we say that customary international law is an important source of principle for English common law, including public policy. in our submission, an outcome which does not require this court summarily to hand Russia the fruits of its duress, condemned on the domestic and international planes, goes with the grain, including public policy, not against it. And I ought to nail one point, which is, contrary to what Mr. Howard has said, we do not say that the bond transaction is not a commercial transaction, nor do we say that in contracting, the parties were not acting as commercial counterparties. Our point is that the threats which induced the contract were not ordinary commercial threats. Hardly the cut and thrust referred to in the passage from Anson, which is cited by Lord Hodge at paragraph 29 of the majority judgment. And one rationale for a restricted doctrine of lawful act economic duress is to avoid upsetting the commercial bargaining process and what parties are entitled to do. If we look at Lord Hodge at paragraph 44, EF 172, paragraph 44, between letters G and H, a commercial party in negotiation with another commercial party is entitled to use its bargaining power to obtain by negotiation contractual rights which it does not have until the contract is agreed. And elsewhere in Lord Hodge's judgment, there is an emphasis on the context of ordinary commercial negotiation. We don't need to go to it, but we saw a reference at paragraph 30 earlier. It's also mentioned at paragraphs 31 and 34. And the application of prima facie lawful economic pressure between commercial counterparties, like Pakistan Airlines and Times Travel, calls for very different considerations to a threatened use of force or where the parties are states where non-commercial interests are also in play. And I'll come back to physical duress in a little detail. And in terms of the second category in Times Travel and how we apply it to the facts of our case, having done Times Travel, I wonder whether it might make sense for me, first of all, to deal with physical duress. And I wonder if that's convenient.
Yes, by all means. 2 o'clock.